Thank you for watching this video. We will introduce the Debt Repayment Scheme or DRS. There will be forms for you to complete and documents to submit in order to help us assess your suitability for the DRS. This introductory briefing for the DRS will cover the following topics: what bankruptcy is and how it affects you, what the DRS is, the benefits of being placed on the DRS, the documents you need to begin the assessment under the DRS, and some of the duties that a person under the DRS must comply with. So what is bankruptcy? Bankruptcy is a state in which a person is recognized by the law to be unable to repay his debts. Bankruptcy commences with a bankruptcy order made by the High Court against the individual, whose particulars will be published in the newspapers to inform the public of this status. The official assignee will be appointed to manage the bankrupt's assets to pay off the debt. The official assignee will take over all of the bankrupt's assets, which include savings accounts, private properties, insurance policies, and private vehicles, which will be sold. The proceeds will then be distributed to his creditors. A bankrupt's bank accounts will be closed and he will be allowed to open only one savings account with the official assignee's consent. Bankrupts will also face restrictions such as not being able to travel overseas or remain or reside outside the country without the official assignee's prior permission. At this point, the High Court has postponed your bankruptcy hearing for a short period so that the official assignee can assess your suitability to be placed on the DRS. If you are found suitable for the DRS, you may avoid bankruptcy. So what is the DRS about? The DRS is an initiative started in 2009 to offer an alternative to debtors who have been unable to repay their debts to do so through a repayment plan. The DRS is voluntary and you may choose to opt out of the scheme. The DRS is administered such that the debtor will clear his debts to his creditors through the official assignee by way of monthly installment payments and bonus contributions. In accordance with the Bankruptcy Act, the length of the repayment plan shall not exceed 5 years. Here's a look at how the DRS compares with bankruptcy. A debtor on the DRS will not have his name published in the newspapers, but a bankrupt would be publicly recognized as insolvent. A debtor on the DRS will not face any travel restrictions, unlike a bankrupt, who will be required to obtain prior approval from the official assignee before leaving Singapore. A debtor on the DRS will be able to maintain his existing bank accounts, while a bankrupt may find his accounts closed with the balances transferred to the official assignee for distribution to his creditors. Most importantly, a debtor will be able to repay his debts within 5 years, while the period of bankruptcy for a bankrupt may be longer. In order to be eligible for an assessment under the DRS, ask yourself if you fulfill all of the following criteria. Your total unsecured liabilities are $100,000 or less. You are employed and earning a regular salary each month. You have not been a bankrupt or been on the DRS in the last 5 years. You have not been subjected to a court-based arrangement with your creditors in the last 5 years. And you are not a sole proprietor, partner or director in any business. You need to submit the following forms for an assessment of your suitability for the DRS. We begin with Form A, or the Statement of Affairs. In this form, you must disclose your assets and liabilities. Liabilities include monies owed to banks and financial institutions, licensed moneylenders, employers or thrift and loan societies, and personal creditors such as relatives and friends. Liabilities also include money owed to the government such as taxes and outstanding termination fees with service providers. Moving on to Form C, or the Income and Expenditure Statement. You must disclose your monthly income and expenditure in order to derive your monthly disposable income. This can be calculated by taking your monthly income and deducting your monthly expenditure. With your disposable income ready at hand, you may proceed with Form D, or the Debt Repayment Plan. You are required to propose a feasible monthly installment amount based on your disposable income. Besides the mandatory submission of your Statement of Affairs, Income and Expenditure Statement, and Debt Repayment Plan, you are also required to submit various supporting documents as listed in Annex B for the purpose of substantiating the declarations you have made. Please note that the Course Book search by e-litigation and the Credit Bureau Singapore search are compulsory. You may have the searches performed at LawNet and Crimson Logic Service Bureau for a nominal fee. While the DRS is voluntary, there are fees payable in the assessment and administration of your case. First, the preliminary administration fee of $350 is payable upon the complete submission of your forms and documents, which will be scheduled shortly. Next, the review fee of $250 is payable before the meeting of creditors for further assessment of your suitability for the DRS. Finally, upon the approval of your DRS plan, the annual administration fee is payable at the start of each administration year at $300 each year for the first 2 years of the plan and $350 each year from the third year onwards. Payments of your monthly installments and bonus contributions are subject to the deduction of both collection and distribution fees at 1.5% and 3% respectively. Should you be found unsuitable at any stage of the DRS assessment, these fees are non-refundable. It is important to assess your suitability for the DRS quickly, as your bankruptcy application has been postponed only for a short period of time. In addition, your debts stop accruing interest once your DRS plan takes effect. If you fail to comply with the official assignee's requirements such as timelines, or if you are not forthcoming with information, you may be deemed unsuitable for the DRS and the matter will be referred back to the High Court, where you may be made a bankrupt. In summary, here's an illustration of the entire DRS assessment process. First, the High Court refers the bankruptcy application that was filed against you to the official assignee to begin the assessment for the DRS. The official assignee then notifies you the introductory briefing. This is the stage we are presently at. Next, you will be scheduled to submit your Statement of Affairs and other relevant forms and documents, along with the payment of $350 for the preliminary administration fee. You will then be required to attend the meeting of creditors, where the official assignee and your creditors will seek clarification on your earlier submission and finalize the details of your DRS plan. You will be required to pay a review fee of $250 at this meeting. Upon the approval of your DRS plan, you will attend the final appointment to make the payments of your first monthly installment and the first annual fee of $300. Upon the conclusion of all the above stages, your DRS plan commences and the bankruptcy application that was earlier filed against you will be deemed withdrawn. However, at any stage of the assessment, should you fail to attend the scheduled appointments, fail to pay the required fees, your liabilities exceed $100,000, or if you are not forthcoming with information, you will be deemed unsuitable for the DRS and your case will be referred back to the High Court. You are expected to change your spending habits in order to maximize your disposable income. The amount to be paid under the repayment plan that you propose must be acceptable to your creditors. You must also take the necessary steps to ensure that you will be able to sustain your DRS plan over the proposed period. You are responsible for the declarations made in your forms and will need to answer questions that may be posed by your creditors or the official assignee. If you have sought the advice of independent advisors, please note that they may not necessarily be correct, and it is important for you to heed the advice of the official assignee.